SJC-13455, Commonwealth v. AZ.
Investor.
Good morning, Honorable Justices of this Court. My name is Devorah Vester, and I represent the appellant AZ, who's here in court today. While hundreds of people boarded in emergency rooms and stuck in acute care hospitals are forced to wait for available psychiatric beds, courts are unnecessarily hospitalizing pretrial defendants under Section 15B just to determine competence to stand trial. In AZ's case, the court committed her under 15B without a constitutionally legitimate basis and no evidence that hospitalization was the least restrictive means of achieving this very narrow purpose. To comply with strict scrutiny, this court should interpret a necessary hospitalization in 15B to mean a likelihood of serious harm and no less restrictive alternative.
Can we divide your argument into two parts? The first is the statutory argument, which reads in the likelihood of harm, correct? And then the second part is the constitutional overlay, which requires least restrictive means. Is that accurate?
It is accurate.
Okay.
Would Your Honor like me to?
Yeah, the first part, as far as the how do you read in to the word necessary likelihood of harm when that's not in the statute?
Yes, Your Honor. Well, the premise is, first of all, that necessary implies two constitutional bases, and the first basis is the purpose of Chapter 123, which protects a person's paradigmatic right to be free of physical restraint.
What I find hard in this case, a lot of things, but one is the dual and constitutional rights, because one constitutional right that's at play that's really not addressed is the right of a defendant not to be tried who's incompetent, and for the judge to get as much information as possible to make that critical determination. Where does that come into play?
Well, that's not in dispute, Your Honor. We agree that that is a compelling and legitimate right. However, that interest is bound by constitutional considerations. And the only reasons why we detain a pretrial defendant is either one, for dangerousness, or two, for noncompliance. And so the argument here is, in Chapter 123, we don't confine a person unless there's a nexus between mental illness and harm. And Section 15B indicates that dangerousness is actually a consideration. And my primary argument—
That's for Bridgewater, correct?
Pardon?
That's for Bridgewater.
Correct. That is the strict security argument is one of them, because as this court stated in KJ versus Bridgewater State Hospital, you can't have a placement finding unless you have a commitment finding. So that's one argument. The other argument is that there is 36C. 36C presumes that a person who's been committed under 15B is dangerous, because after that 5-year period, the prohibition on owning a firearm is over, a person has to proactively go back to district court to prove that he or she is no longer a danger to public safety.
Boy, that's a lot of work for statutory construction to do that. I understand, and I'm interested in your constitutional argument, but the statute, what's the necessary for the statute is that, and I'm interested in hearing you attack the premise too. But the point is, okay, 15A didn't really give us our answer. It's
right.
Necessary to have inpatient here, and I'm happy to have you push back on that when we get to it. But as far as where Justice Gaziano started, I'm having a hard time with the statutory argument.
Well, let me try to unravel this here. So, pretrial defendants have one foot in the mental health door, and they have another foot in the criminal door. And what the argument is that pretrial defendants should have the same due process rights as non-criminal, non-forensic persons under the mental health statute, and also the same due process rights as pretrial defendants who don't have a mental illness. And in Chapter 123, we don't commit a person unless there's this nexus. So the presumption is that outpatient evaluation is the default.
Isn't due process satisfied by the hearing and the judge's determination that I don't have enough information from the 15A? I need two things, a 20-day minimum examination or observation, I'm sorry, plus another examination by a different provider, so I can get this information to make this important decision. Because you don't get, if you have inpatient, you don't get the 20-day observation. I'm sorry, outpatient. I misspoke. You don't get the 20-day observation, which is critical to the finding.
Well, Your Honor, when you get to 15B, well, let's back up. After the 51A exam, the clinician's opining that the person needs a further evaluation. But liberty needs to be the default, because that's the premise of Chapter 123.
Right, and so your argument is really not so much a statutory one, but that we need to read 15B so as to permit it to be constitutional, and that you're reading into the word necessary things that would be required to save it to be constitutional.
That is correct, Your Honor. However, from the statutory point of view, again, if the floor is not a likelihood of serious harm, then we get to the situation AZ was in.
Well, I'm sorry, go ahead,
No.
Justice Graziano.
I was just going to suggest we move to the constitutional argument, because that's really, I think, as Justice Wendland says, your best argument, and I want to give you enough time to answer that, unless Justice George has had a different question.
It was one question before on
Please.
the statutory interpretation before you move to that. Because what I have the difficulty with, this is still an abuse of discretion standard we're dealing with, right? At least on the finding of the 15B. And why I mention that to you is because you say in this case, but this case, if you look at the record, the clinician's testimony to the judge was uncontroverted. All of the things that you're saying were all argument that was made by the defendant's lawyer. There wasn't evidence. The only evidence that was presented was the evidence of the clinician saying that the further evaluation was necessary under 15B, and that Solomon Carter was where the defendant ought to go, and that was uncontroverted. So reading into all of this other stuff when there was no evidence of that, and when there was already funds that were given for your own evaluation, there were additional funds before the hearing was I'm struggling to see the statutory argument when there wasn't any evidence of any of this in front of the judge that made the ultimate 15B determination.
The statutory argument, Your Honor, is that there needs to be a presumption that outpatient is the default for a further evaluation, because an outpatient evaluation, there's no mystery to any of this.
I want you to get to Justice Graziano's point, but we're only doing that if we're reading words into the statute that ain't there, right?
Well,
This implicit standard of a likelihood of serious harm, that we've got to read that into the statutory language that isn't there.
it is correct that those words are not in the statute, Your Honor, but this court has read words into the statute. In Nassar, for example, imminent likelihood of serious harm. The word imminent doesn't appear anywhere in 8A. Also, less restrictive alternative. We all know that even if a judge finds a person to be a likelihood of serious harm, the analysis doesn't stop there.
Well, less restrictive alternative is a fundamental right, substantive due process standard, correct?
Correct, as this court had held in Minor. However, earlier in Nassar, that was a statutory interpretation, because Nassar said that all who are concerned in the administration of the law need to find the least oppressive, least burdensome controls over the individual consistent with the purpose.
Is it fair to say if we get to where you want to be, it doesn't matter if we go statutorily or constitutionally?
I don't know that it doesn't matter, but
All right, let's pretend it doesn't. Okay, next question. So fundamental right, that's clear because it's a liberty interest. And then we have to look at two things is it narrowly tailored, and then, importantly, is it the least restrictive alternative? That's what fundamental rights require, correct?
Correct.
And is your argument that the least restrictive means available means that the judge ought to consider the outpatient avenue?
It means that the judge must consider,
I'm sorry.
outpatient. And the fact that a clinician opines that someone needs further evaluation doesn't translate to inpatient. And I think
that's where I'm getting at. So it's the same question that I have. Under the constitutional framework of least restrictive alternative, that doesn't happen in the ether. That has to be on the basis of evidence. What evidence was there that this could be done outpatient other than just attorney argument? What evidence was before the judge?
Your Honor, I don't believe there needs to be evidence that it can be done outpatient. I believe.
Well, I say that in the context of there's affirmative evidence from the clinician that that inpatient is the most appropriate place. So wouldn't that be the floor? Wouldn't that would the evidence in front of the judge be, well, that's the least restrictive because that's the only evidence that I have?
Your Honor, if I may, the clinician didn't testify that hospitalization was the least restrictive means. What she testified to was that if AZ wasn't hospitalized, then she might deteriorate, and therefore she needed treatment. AZ was hospitalized for treatment, and treatment is not constitutionally cognizable under 15B.
I would push back on you on that. The clinician was testifying in the context of competency, that in order for her to meet the legal definition of competency, she needed to get treatment to get to that point. It wasn't treatment removed from the central issue of whether or not she was competent for purposes of the prosecution. It wasn't removed from that.
Your Honor, the judge in this case found there were two reasons for hospitalizing AZ. The first one was mental illness, and the second one was treatment. And neither of those reasons pertain to the very narrow purpose of 15B. It's a mere competence evaluation.
But can I ask on that, to follow up on Justice Gaziano's question from earlier, which you didn't really answer? Can you do this type of competency hearing outpatient? I mean, you've got enough concerns about competency. You're going to do this through someone showing up for a couple of hours, a couple of times a week. Don't you need that period where someone is constantly under observation to make that kind of call?
No, Your Honor, I believe the amicus brief speaks to that competence evaluations are very straightforward and just as rigorous as inpatient evaluations, and probably more effective. The clinicians are just as qualified to make this determination. It's not rocket science.
But can
it
I
can
ask
be done in the
then
community.
follow up on Justice George's question? Do we have that in the record as opposed to the briefing? And who has the burden of proof on that? Is that the Commonwealth or or you?
In this particular case, since the Commonwealth was the moving party and insisted on a competence evaluation, I believe the burden was on the Commonwealth in this particular case. And again,
In fundamental rights jurisprudence, who has the obligation to prove the least restrictive, when you're doing this least restrictive alternative?
In the context of an existing statute.
well, I think that's unclear because
Well, it must be the Commonwealth. I
Right,
mean,
'cause
it
it's a
must be the government who has this overwhelming interest that must also show that it's the least restrictive way of accomplishing that interest.
Right, 'cause
How could it be otherwise, that you would have a defendant or just a garden variety civilian who'd have the burden of showing that there were other alternative ways?
if I'm understanding Your Honor correctly, you're saying that if the Commonwealth is asking for the evaluation, then the Commonwealth has the burden.
Just as a matter of constitutional law, I've never heard of a strict scrutiny application where it's the person suggesting whose liberty interest is at stake who would be required to make the showing.
I agree with that, Your Honor, but also the court can sua sponte.
But that's still the government, isn't it?
I guess it's still the government. I think in any event, the defendant shouldn't have to prove anything to get her outpatient evaluation. And that's my point. That should be the premise, and that's what we're asking this court to read into this statute to uphold a person's right to be free from physical restraint. And if there's evidence otherwise, then that evidence can come forward.
Can I ask you how this would work in practical terms, right? So you're here for your 15A, and they bring out the court clinician. Would it be incumbent upon the defense attorney to say, I have an outpatient alternative that I'd like to propose to the judge so you can get the information before you commit the person for 15B? Is that how it works?
Well, I don't think that there should be a burden on the, again,
How's the judge going to know about an outpatient alternative unless he's given that information?
Well, the attorney clearly can propose an alternative and should, but what I'm saying is I don't think that the defendant should have to prove that. I think that should be the presumption, the default.
Okay, so the judge says I should, under the case law and under the substantive due process, I have to consider the least restrictive alternative. The judge has to think about whether or not an outpatient evaluation would be appropriate to have the same decision-making that goes forward. How is the judge going to know what to do? I'm just trying to think this through, if we rule in your favor, how this happens in the BMC and the district courts.
Unless the person is voluntarily going into a hospital to have this very simple, straightforward examination done, the presumption is it's outpatient. The judge orders an outpatient evaluation. And
this only applies, by the way, to people who are not incarcerated.
Correct, because we're talking about people who are living in the community, who have lives, who have jobs, who have housing, and who stand to lose all of this. You can lose all of this within 20 days, not to mention 40, because the statute permits up to 40 days. But if the judge orders outpatient and gives the person the opportunity to succeed or fail, then if the person fails because the person doesn't show up, there's noncompliance, everyone comes back to court, and the judge has tools in her toolbox to decide how to handle this because she needs the information. We don't have to go immediately to a 15B. The judge can.
That's the next question I had. Can I then ask you, as far as the amicus brief goes, it suggests that this isn't really outpatient isn't really a 15B examination. It's a continuation of a 15A.
Yes, it is akin, I guess, to an extended 15.
Right. So what's your position on that? Does it matter if it's the next step on a 15B or if it's a continuation of the 15A?
Well, the language of 15B, as we know, is discretionary. So the judge can order hospitalization or the judge can order outpatient. So I don't necessarily think it's an extended eval under 15A.
So we preserve the 15A clinician evaluation, and the judge, under your scheme, says, what should I do? Is it necessary with the least restrictive alternative to have a 15B hospitalization, or can I do a 15B outpatient?
I think that the 15A is only there to separate two groups of people, right?
One group, no-go. Yeah.
They're going to trial, and the other group, their competence is questionable. And so if liberty is the default, and we see it just like in 58A, where pretrial release on personal recognizance is the default, and then we start chipping away at it in a least restrictive alternative analysis until we get to a place where there are no conditions left that will satisfy the narrow purpose.
But isn't there an additional complication, back to Justice Gaziano's dueling constitutional rights? Because this isn't just a mental health hospitalization. You're protecting the defendant's rights not to be tried as incompetent. I'm just worried that you're asking for an abbreviated process. It may be the least restrictive in terms of the patient's liberty, but it may be more problematic in terms of determining the patient's competency because a 20-day evaluation is different than a showing up for an outpatient. You may be one of those people who goes in and out of mental health, right? And they're going to see that within 20 days, but they may miss it if they're doing an outpatient, right?
Well, again, Your Honor, I would refer you to the amicus brief, which clearly outlines the ease with which an outpatient evaluation can be conducted in the community. I think these are all assumptions not based on evidence that...
But then do we need to remand this to develop that record in a better way?
In this particular case, or...
Well, this particular case is complicated because at one point she's found dangerous, at one point she's not, at one point she's found competent, at one point she's not. I mean, it's a tricky case.
And then ultimately, the case for all of the procedural rankings resolves on the pretrial probation where there's no allocution whatsoever.
Yes, and
The complicated case.
I would like to say it's not as complicated as Your Honors believe, because AZ, even though she was found dangerous, she was in the community because the judge found that there were conditions that would satisfy any safety concerns the court had. And she didn't violate her conditions, and no matter how many times the Commonwealth tried to revoke her bail, it didn't succeed. She stayed in the community, she had her life. And the evidence before the court was twofold. That one, she appeared to not be able to communicate effectively with her counsel because of her presentation, which included symptoms of mental illness. And on the other hand, the clinician was worried that if her condition went untreated, she would continue to deteriorate. But that has nothing to do with 15B. Unfortunately, that 15B is very, very narrow, and it's...
That's a byproduct of the 15B process, right? Is the treatment. But I take your point that that's not the purpose or the constitutional purpose of a 15B.
I don't even know that it's a byproduct, Your Honor.
But of course it's a byproduct, because if someone is committed and then they're on the right medication, they get stabilized, et cetera, you've seen that. The people get better sometimes during these evaluations.
Well, and people could also get better in the community, Your Honor, and she was in regular therapy per her conditions of release. She was taking her medications. And,
And I'm not saying that that's a way to resolve this case. I'm just saying that's a reality.
right, but again...
And you're asking for a broader rule, right? You want us to create a presumption in favor of outpatient evaluations. It sounds like to me, right, that, and that's a big step that we don't necessarily have a record for.
I'm asking this court to interpret 15B as presuming outpatient because of the fundamental right that a person has.
I get the legal stuff, but do we have the factual record, an evidentiary record, to make that call that outpatient is just as good or the same as? I mean, I just don't. I've read the decision, I've read the back and forth in court, but I don't know. Do we have enough? Mm-hmm.
Yes, I believe this court has enough on the record because, again, the only two reasons for her commitment were mental illness and treatment, which are outside the scope of 15B, and that's it. There's nothing in the record. The Commonwealth was silent the whole time, except for saying to the court that it was not opposing the 15A or 15B because we're not here before Your Honor on a 16B. It wasn't in opposition. And so since the Commonwealth in this case perhaps had the burden because it wanted the competency evaluation to be done and it brought no evidence, I believe this court can make that ruling. There was no evidence that an outpatient would be less satisfactory than an inpatient evaluation. And we have to defer to the right to have liberty and be in the community and have the evaluation, which is very straightforward, done in the community.
You're well over your time. Thank you, Attorney Vessler. We'll hear from Attorney McGee.
Thank you.
Good morning, Justices of the Supreme Judicial Court. My name is Michael McGee. I'm here on behalf of the Norfolk District Attorney's Office. As this court stated in Commonwealth versus Garcia, General Laws, Chapter 123, Section 15 is narrowly tailored.
Well, it's always the footnotes that get us.
I don't know, who wrote Garcia?
So I went back to the briefs to figure out, and first of all, the first half of the footnote suggests that it's an open question. But the whole argument of the Commonwealth was about 15B. And so, as I was thinking about it over the weekend, I guess that's why the footnote's in there. But it's just a footnote. It doesn't dictate our determination here.
No
I
such,
wouldn't build your whole argument around a footnote in Garcia.
well, some footnotes are better than others, and I would suggest in this case, this is not mere dicta, that the court went out of its way to distinguish it from 16A.
Well, it is dicta, but it's in there because the whole argument was about 15B and that the world is going to collapse if we require this substantive due process analysis under 16, and that's going to get infused into 15, and then there's going to be a big problem.
You should know that Justice Lowy is big. Carolyn footnote product is one of his big things, so he likes footnotes. Don't let him tell you otherwise.
Let me ask you, on the substantive due process, right, let's skip to the,
Yes,
to I think what is the main argument. You agree, of course, that a fundamental liberty interest is involved.
absolutely.
And then the standard then becomes whether 15B is narrowly tailored to achieve a compelling goal
Yes.
and also has to be the least restrictive means available of achieving that goal. That's the standard.
That's the standard, yes.
All right. Why isn't outpatient the least restrictive means of achieving that goal?
What I would suggest is a statute, and
This
is
is a constitutional overlay to the statute.
Right.
So it's not statutory language. Assuming you win on that one, I'm more worried about, or not worried, I'm more focused on the constitutional overlay.
I think what's really important to understand here is that there is a neutral and very compelling interest in having a defendant that is competent to stand trial, to be convicted, and to be sentenced.
Right, so you have a compelling state interest. Why is this the least restrictive alternative?
Because, and the liberty interest at stake here is narrowly tailored to that interest.
We've got that, though. We checked that box. as far as
Absolutely.
Right, so
narrowly
you have a
tailored.
compelling state interest to only try competent people,
Correct.
right?
And that goes-
Absolutely, I get it.
Right.
Why is this 20-day inpatient the least restrictive way of doing that?
That also goes to procedural due process and the manner of, and these words.
Yeah, but
So-
we've got, we have
Right.
procedural due process. You got the hearing, you had a right to be heard.
Right.
You had a lawyer. Now we got to get the least restrictive. We still got to get you down to that least restrictive alternative in Justice Wendland's question and my initial question.
Well, you have to take into consideration all of Section 15 and what happens before that and what the legislature intended. And this language in here is conclusive as to that legislative intent. And that what happens before here is that you have a qualified clinician or two opining, reporting to a judge what exactly happened.
Good, you're good. You're gonna win that argument,
Correct,
and you get 15D.
Right.
You're good. When we're trying to figure out whether or not you actually need inpatient to be able to get the right decision on competency, what's our record if this is the least restrictive alternative? We've been talking about, those are legislative facts when you're connecting whether
Correct.
or not the least restrictive alternative. So on this record, we've got amicus briefs
Yeah.
that are raising the issue. Constitutional, you got to deal with the constitutional issue. How do we know? This is the question that I think Justice Kafka was getting at, and I'm having trouble with. How do we know that outpatient's just as good? Because if outpatient's just as good, then you just don't need to send the person for 20 or 40 days and have them lose their job and have beds being taken up while people are boarding in emergency rooms trying to get Section 12 commitments.
I would suggest that that issue,
Can I piggyback on this so you can get that right after Justice Lowy's point? Because I really want to go back to how, as a practical matter, this works. Because if we're looking at this hearing, there's testimony from this clinician that Solomon Carter is where. So whose job is this? After you answer Justice Lowy, could you answer that? How is this supposed to work? Is the DA supposed to go out and research community facilities for this? Is the defense lawyer? Is the judge? Who's supposed to do this at the time of the hearing? If you could get that after Justice Lowy's question, I would really love to know how this is going to work.
just starting with whether this is properly before the court and you have enough information, I would suggest that you do not, because the evidence before the court was argument. You had one qualified clinician presenting a case after having met with this defendant twice.
Don't you
So on
lose?
insufficient information, you deprive somebody of their due process.
Absolutely not. This person had a hearing, had an opportunity to be heard.
Well, their liberty interest, I should say.
Yes.
On insufficient information, you deprive somebody of their liberty interest for up to 20 days.
This particular defendant had exactly what that statute.
I'm not quibbling with you on the statute. And it seems like, and maybe this is purposeful, but I'll give you one last chance.
Yes.
It seems like you're avoiding the constitutional issue, which is what in the record tells me that 20 days inpatient is the least restrictive alternative to deprive this defendant of her liberty interest.
Because the overriding interest is that neutral interest in being found, being
Okay, so you
competent
have
to
a
strike.
compelling
So
state
there was a-
interest, and so because you have a compelling state interest, therefore I can put somebody away for 20 days?
When a judge has reason to believe that it is necessary to either hospitalize someone at a DMH facility or at Bridgewater State Hospital if they're a male and require strict security, to determine whether their mental illness.
That's the statute, right? So you're saying
Yes.
that the statute gives me the fact that this is the least restrictive alternative.
Correct.
Okay, and there's nothing other than the statute, which is what we're trying to question is unconstitutional or not, that in this record that shows that that was actually the least restrictive alternative.
It is conclusive to the legislative intent to have a competent
Absolutely.
defendant.
Yeah, but that's not helpful.
Yes.
Because, I don't mean to cut you off.
Yeah, I don't think it is helpful because the question is, you know, we don't have, what you're saying is there's nothing in the record to say that this was not the least restrictive alternative. But when the government is depriving somebody of their liberty interest, that failure generally does not do well for the government in terms of the constitutionality of a statute.
The two things, Your Honor, and this maybe answers another question earlier, is that the record actually was clear as to whether this was the least restrictive alternative. The qualified clinician here spoke about why this particular defendant was not appropriate for outpatient. This defendant stated specifically to the clinician that she didn't have a mental illness. However, she had a history of being bipolar. She was having difficulty with a companion that was coming to court with her. She was violating conditions of release.
You probably know the record better than I do, but
course.
my memory of the transcript, I read the hearing, was the clinician gave these facts, but she gave them as a narrative. That wasn't asked as far as, is she an appropriate candidate for outpatient because of those factors? So you're taking the facts, which I don't, and you're saying the judge could have found, because of the denial of that right, the denial of mental illness, that she wasn't appropriate for outpatient. But the clinician never was asked, is this a good outpatient candidate, correct?
She made that recommendation based upon her training and experience and her.
So she says, here are the facts. They include a denial of mental illness. Based upon all these facts in my experience, the person needs to be inpatient. But there was no question posed about outpatient to the clinician.
I can tell you that a very zealous defense attorney advocated strenuously and saying all of the things that counsel has said today to that court. Her car's in the parking lot. She's going from the street to Solomon Carter Fuller. This is completely unnecessary. I've sought funds from her. All of those arguments were made to the court that day.
But the problem is the judge cut that when she does that, So this is well argued. So she says, you can do this outpatient. The judge doesn't redirect to that point, does he or she? The judge kind of just says, the judge doesn't address the issue or allow the expert to respond to that. That's what worries me a little bit, that we don't know, no one, although they propose the outpatient alternative, no one explains why an outpatient, it may be implicit, you say, but no one explains why. And now this case is here being argued that you should use outpatient rather than inpatient for these 15 Bs.
I think this analysis discounts the important resource that a designated forensic psychologist or psychiatrist is to the court, and all of the requirements and qualifications that is necessary for them to be testifying in court, their knowledge of the competency and criminal responsibility standards.
They're knowledgeable, and I know they're the right person, but they're not asked the question, could you do this outpatient, right? Don't we need to know the answer from the expert on that? I mean, again, it may be implicit but the judge kind of says, okay, she says go do this 20 days. Nobody responds to the lawyer, do they?
The judge on page 19 talks about the presentation by Dr. Robinson, and then the judge says, Dr. Robinson was concerned she may not be a good candidate for voluntary treatment.
Correct.
So he gets all the information, considers whether or not she's appropriate for outpatient, and concludes otherwise.
It was well within his discretion to do so.
Is that, by the way, that may be exactly right, but when they reference voluntary treatment, is that code for an outpatient evaluation?
Yes. It's not, it is exactly that. And going back to this point about, and what Justice George is asked, is who is the best person to make these decisions? It's the judge that's in the courtroom there, and there's plenty of case law about pointing to Schianti that's cited in my brief, about seeing the courtroom, seeing what's going on there, seeing the parties, talking to court officers, taking information. But the expert, that person, that designated forensic psychologist that's working with the Department of Mental Health, understanding whether the facilities are at census, whether that person, there's a bed for them, all of those things are well within the realm of a designated court clinic. It's a really important resource to a judge that's has a whole host of issues in front of them, and they're relying on a qualified clinician that understands this and understands all of the macro issues that are going on that the defense justifiably has concerns with.
I'm sorry.
No, go ahead.
Do you believe the judge needs to make it constitutional, the judge needs to consider that least restrictive alternative?
I believe that whenever there's a deprivation of liberty, that analysis should be considered.
Okay, and then in this case, are you arguing the judge did consider and reject that alternative?
And oftentimes and most of the time, it's something that's offered by that DFP. They are standing there in front of the judge and they're saying, this can be done outpatient. This juvenile, this person that's got a support system in place, doesn't require that, or I want them to meet with me on a regular basis and I'll write a report to the court in 2 weeks. That happens all the time. In this particular case, there was a myriad of issues going on with this defendant that didn't exist at the beginning of the case, including all of these violations of, or alleged violations of conditions of release, and she didn't recognize her mental illness, and it was well within the judge's discretion to credit that.
So is there anything wrong with us holding this is required, that because of the constitutional overlay of this statute, we need to have a finding that an outpatient evaluation for competency is not appropriate in these circumstances? It sounds like you're saying you win the case, but again, we deal with rules, not just cases here. So isn't that required, and is there anything, what would be wrong from your perspective with us requiring an express finding that an outpatient competency evaluation is not appropriate before putting someone in for 20 days?
I would suggest that the court need not insert any additional standards or requirements upon the court. Here, if there was
done
no
that-
need for an
we've
outpatient, there would
Done
be,
that in section 35, though, right? I forget the, I think it's EC. We did that in section 35. We do that all the time.
correct.
To make these statutes and 123 conform to Constitution, to the substantive due process, right?
For civil commitments.
Right.
And they're certainly different.
Guess your argument would be that here, the record reflects that there was a legitimate reason to have an inpatient under 15B to get the evaluation, and that when we have a record that's vibrant and that we can dig into, and the issue is right before us and we have to reach it, then we should reach the constitutional issue.
What I would suggest is that competency comes up all the time and in many different phases of a case, and it is so important that a judge is required to address it sua sponte. There are many cases where it simply does not go past a 15A, or even require
We're
a
not
15A.
worried about
This is
that.
relatively narrow, though, because this,
Right.
this entails someone who's not presently confined, who already has a liberty interest that's deprived, because pretrial detention also doesn't include the dangerous people who are sent to Bridgewater.
Correct.